Welcome back to Story Hustler, Murder, Mayhem, PTSD. I'm Dylan.
And I'm Mike.
Like and subscribe. We're just going to jump right in. We have the sentence hearing of Heber Jeffs that happened recently. It's pretty interesting. It seems to connect the dots, and then it leaves you heartbroken at the end.
Right. It's this is a story we've been following for a long time in the wake of Warren Jeffs' revelation last year, and we've seen a number of what we think are real tangible crimes: kids being kidnapped, abducted.
For the purpose of marriage, let's just
and gathering them up in North Dakota, and law enforcement had one case where they busted a guy. It was a great case where they could have set an example.
It was Warren's nephew, so close to home.
And the prosecutors and the cops seemed to think it was all part of Warren's conspiracy. They said as much, but at the end of the day, they let Heber Jeffs walk with the sweetest deal you can imagine.
And not only that, Heber's lawyer then went on to ask to introduce alternative facts that Heber was such a great guy, and he really had the best intention, and he loved this girl.
It wasn't good enough that he just got a sweetheart plea deal. Then during the sentencing,
in case he gets in trouble again, it needs to be on the record that he didn't ignore the sheriff, and he didn't try to evade law enforcement. He didn't kidnap the girl with the malicious intent. He loved her dearly. He was a great father figure. Her mother didn't care.
The prosecutor said, as he called it out, said they were lies. They were offensive, disingenuous lies, but still
they were harsh to him. Like, the words they used were impressive, but then they just
no, all bark, no bite.
Yep.
This is the recent sentencing hearing for Heber Jeffs. In our next episode, we promise we will be back with some
deep dive into our analysis,
pointed commentary about what has happened with this case.
Let's let it roll.
Please rise. 6th District Court for the State of Utah, for the County of Pine, Mr. Honorable Marvin Bagley presiding in the city. May be seated.
Good morning, everyone. Today is June 12th, 2023. This is the law in motion calendar for the 6th District Court of the State of Utah, sitting in Paiute County. The first case on the calendar is State of Utah versus Heber Pearson Jeffs, case number 221600011. See Mr. Burton here, along with Mr. Burns. Matters on the calendar for sentencing.
Good morning, Your Honor. Scott Burns appearing for the state.
And Steve Burton appearing for Mr. Jeffs. Would the court like Mr. Jeffs and I to be at the lectern or here at the table? What's the court's preference?
You can be at the table as long as we can get a good recording. So we're ready to go. Okay. All right. The clerk just informed that there's some issue with recording, so we need to make sure that we hear you good. So
Understood. We'll do our best.
thank you. All right. The matters on the calendar for sentencing. There has been a pre-sentence investigation that was conducted and a report that was written, which made a recommendation as to the sentence. I've read that report. This morning, I was just handed a document entitled Defendant's Correction to Pre-Sentence Report and Supplemental Sentencing Materials. I had a chance to review that this morning. So if there's an agreement, I'll hear it. If there's not an agreement, we'll hear argument. We'll go, in that event, we'll go first to Mr. Burns and then to Mr. Burton. Anybody else they want me to hear from, and then Mr. Jeffs gets the opportunity to speak if he chooses.
Judge, I believe there is an agreement in place, and of course, if the court has any questions or would like a statement from defense or defense counsel, we can also provide that, seeing it as how it is sentencing and the court is not bound by our agreement.
When I said if there's an agreement, I didn't want to preclude either side from making any statement they want to. So, Mr. Burns, do you want to say anything?
Well, the state concurs with the pre-sentence investigation report, and I believe that it is consistent with what we discussed prior to the defendant entering his plea. I was handed this morning the document prepared and provided by counsel and the defendant, and that does concern me. There are things in that concern me, and I don't know if the court would like me to rebut those, or what the state believes would be rebuttal now, or to wait until after the defendant and counsel have made their statement. But I think I need to make a record if that's going to be filed as a document with the court in relation to sentencing.
I think the document can be filed, but I had an issue that I need to clarify too. Mr. Burton, are you asking that there be a change to the pre-sentence report, or are you just acknowledging that you don't agree with it? That's the question I have.
Yes, Your Honor. So I know that typically in most sentencings, after receiving a pre-sentence report, the court says, are there any corrections that the defendant would like to be made? And I think depending on the judge, sometimes the judge likes to do interlineations, but most of the time they just make a note as to the things that we don't agree with. That our request would be the second. We're just asking the court to take note of the things that the defendant would want to correct on the record, as far as things that they think are factually different than what actually happened.
Typically, if a defendant goes to prison, the PSI follows them, and there's more of a request on defense counsel's part to go back and have it corrected, because it will be relied upon later. I mean, there's still always the possibility, even in view of any stipulation, that he could still go to prison. So,
Yes, I understand, Judge.
But if your objection is for purposes of sentencing today, then I'll just hear you. But if you're asking that we go back and make a change, then we'll need to address that. So
No, that's exactly right. We'd like the court to be aware of those things. And I believe that, the parole board eventually, which we don't anticipate will be part of this case, but they would consider anything that was provided to the court at sentencing. So that's part of the reason why we wanted it to be in the record, but we're not requesting that the pre-sentence report be changed physically.
Okay. All right. Well, if that's the case, do you want to make a record? Mr. Burns said he wants to respond to it. So do you want to say anything about what you filed?
I think just briefly, Your Honor, just kind of as part of our statement during sentencing. Is that okay?
That's fine.
Okay.
All right.
Your Honor, I think what Mr. Jeffs would like the court to know more than anything is that that from the beginning of this case, from the beginning of his interactions with the juvenile TKB, he always had the best intentions for her. He and his wife agreed to take her in when she was 7 months old and cared for that child until she was almost 8 years old. And they treated her just like any one of their other children. And I think that the statements that the court received confirmed that they gave her a good life. They did everything that they could to try to take good care of her. They gave her medical care. They educated her. They helped her learn and develop just like any parent would with their own child. And that's how they treated her. And there were some statements made in the pre-sentence report about Mr. Jeff's defiance towards law enforcement. I want the court to understand that that was not his attitude. I think that the prosecutor was given information that would have suggested that kind of attitude or defiance. But it's important for the court to know, and this is one of the reasons why I wanted to include these corrections, is even though some of the evidence says that a process server left a copy of a court order at Mr. Jeff's residence in Beaver, Utah, he's never lived there. He was shown the address and the home. They don't know where that address came from. Quite frankly, we're interested to find out how the process server got an address where Mr. Jeffs and his family never lived. But unfortunately, that became part of the narrative that, in fact, he had received a court order and he was just ignoring it. That wasn't the case. He had received, and he does acknowledge that he received text messages from the sheriff, and he, in his mind, he didn't see it as something that was extremely serious. He didn't know that there was a pending criminal charge.
So, let me just interrupt here. So, you're saying he acknowledges receiving text messages
Yes, Your Honor.
from the sheriff
Yes.
telling him there's a court order.
Yes. I don't believe it told him there was a court order. It was asking for him to contact back.
Okay. All right, go ahead.
And he wishes he would have opened that line of communication and returned that the message from the sheriff. Your Honor, I think that he really wants the court to understand that he's willing to do whatever he needs to do to communicate to the court that he's taking this seriously. He drove 19 hours, he and his wife drove 19 hours from North Dakota, where they now live, to be here this morning. And they'll drive 19 hours back because he wanted to be here in person to show the court respect and do what the court asked him to do.
Well, he risks going to prison if he didn't.
Yeah.
So I don't think that's
That's another great motivation, but even instead of asking to appear remotely or anything like that, which I think may have been a reasonable request, he wanted to be here in person and again just show his willingness to do what the court asked.
right.
I will ask the court also as one last consideration to follow the recommendation to consider that that Mr. Jeffs and his wife did everything that they could to give TKB a good upbringing and a good life. And when he was contacted by his sister, TKB's birth mother, and she said that she wanted to take TKB back, he was worried, as anyone would be, I think, when they've cared for a child for 8 years. And he wanted to make sure that he was trying to do what was best for the child. And he still wishes that. I know that in the pre-sentence report, there was a request that there be absolutely no contact. We're actually asking the court to allow for that pursuant to Ms. Rose Jeff's stipulation or agreement. So we think that now that she is in the custody of Ms. Rose Jeffs, if she decides that that's the best interests of the child, then we think that would probably be important to allow contact, or at least the possibility for contact, for the person that she knew as her father for pretty much all of her life until she was 11 years old.
Thank you. Mr. Burns?
Thank you, Your Honor. 2 or 3 things I would like to state directly in response to the sentencing memorandum that was filed. First of all, I find it a bit offensive that they have this little girl writing statements. And I don't know if they were written before or after she was returned to her mother, but to have a little girl sit down and write, boy, I was in a great place and they treated me so lovingly, and gee, aren't they great people? I don't necessarily know if it was coercion or Stockholm syndrome or what, or just having control for 9+ years over a little girl, but I don't think there's any place in that for the court to consider. Second thing is, I find it disingenuous, if not a lie, for this defendant to state that he didn't know, or if somebody would have told me, or I don't have a residence in Beaver, or they tried to serve something in St. George. He knew that this little girl was not his daughter. He knew that Rose Jeffs had gone to the home previously in Kingston. And he also knew that he told his sister, quote, "Things are going different now. I'm going to be doing things different." It's common substance. And that was on the heels of a revelation by Warren Jeffs. And Rose Jeffs, who is the daughter, as is the defendant, of Warren Jeffs' older brother, she knew what that meant. And she has left the church, and she doesn't want anything to do with the church. She has no ill will, has no bad statements to say about the defendant, Sarah Jeffs, or any part of the religion, but she wants to be done. She wants nothing to do with them, and they want them to leave her and her daughter and her other children alone. And I think it's pretty telling when the defendant in the pre-sentence report, the pro-criminal attitude said his actions over the past several months exhibit a support of crime and disfavor toward convention. He disregarded the judge's order to return his niece custody of his mother. He seems to feel justified in keeping the child from her mother and stating that the girl was doing well under his care. And he claims that his sister is struggling financially and her other children were falling behind in school. So he's the judge and the jury and the determiner. It's all up to him. He knows how to raise kids and whether they're doing well or not. And it's offensive. He's not her father. He's never been her father. And the good news, Your Honor, in all of this, in an hour-plus conversation with the mother on Friday, this little girl is doing well. This little girl is happy. She is looking forward to going to school, public school, in the fall. This little girl is now wearing clothes she wants to wear, and she's found a friend in the neighborhood. And gosh, is it okay if I ride a bike with my friend? And, after 9+ years of being in one environment and transitioning to another environment, I think the last thing this mother needs, Rose Jeffs, is for contact or needling or any part in her life. And if they want to do that, I think there's an appropriate means to do that. That would be an order or a petition with this court or a filing in a civil court if they think they have a compelling case. But please, after all we've been through, and if the FBI couldn't find him and the U.S. Marshals couldn't find him and the Attorney General's office couldn't find him, but the Sheriff of Paiute County did finally find him and direct all them to where he was, he knew they were coming for him, and he knew he'd committed a law violation, Your Honor. And so I think that record is important. In response, I didn't want it to just be all one-sided, file this with the court and me say thank you, Your Honor, and sit down. So I appreciate the time.
Thank you. Back to you, Mr. Burton.
Thank you, Judge. I'm a step parent. I never adopted my stepchildren, but I acted as their father for pretty much their entire life after marrying my wife. And I put myself in Heber's shoes and in this little girl's shoes, and I think that he was trying to do the best he could. And just to be clear, he didn't receive any support to help raise that girl. He supported the girl financially. He and his wife raised the girl. They considered her one of their children, their youngest child. She was just about 1.5 years younger than their youngest child. So they took her in, they took her to all the family vacations. Anytime they'd go to a job, she'd come be with the family. All of their kids, she considers her siblings. Their entire experience with her was trying to do the right thing because her biological mother wasn't in the position to be able to take care of this new 7-month-old child. And Judge, I think that that's really important for the court to understand too. They received her when she was 7 months old. So from 7 months old as a baby, they raised her and they tried to provide her a good life. And I don't know if Your Honor has children, but if you know the kind of love that develops between a parent and a child, when there's a question about what's going to be in that child's best interest and how to successfully give that child a good future and a good life, I think that a parent who has spent that much time and that much effort trying to give that child a good life would want to make sure that that was the right thing to happen. I think that the prosecution mentions some kind of religious order. Mr. Jeffs is unaware of any kind of order or direction or anything that told him what he should or shouldn't do with TKB. Literally, it was conversations with he and his wife deciding what should happen. And he mentions that Mr. Jeffs talked about, well, circumstances had changed. And essentially what had changed is Ms. Sarah Jeffs had gone out to work. And so Mr. Jeffs was the one making the family decisions and trying to decide what to do and what would be best with the child. All in all, Judge, I just want the court to see and understand that all of the evidence that the court has from the people who knew the family is that he took great care of her. He and his wife took great care of her and tried to give her everything that they could to have a successful life. There's no indication of any kind of abuse or mistreatment in any way. And I think that it's important for the court to understand that that was all of their efforts over those 8 years that she lived with them. Excuse me, I said 8 years. It was, I think it was more than 10 years. It was 8 years until she had contact again with her mother, Rose Jeffs.
And Rose would defiantly dispute that, Your Honor, and she finds that offensive. And the only thing I would say is, I'm sure Mr. Burton is a great step-parent, but if he just grabbed those children and took off and was found in North Carolina by the biological father, it'd be a different story. I also doubt Mr. Burton would be so haughty and arrogant to be of the mind that he knows far better than anyone else in the world how to raise this little girl or what's in her best interest. And I think that does fall in line with the male-dominated system and religion, frankly. And I think it's a lie to say that he was just going to North Dakota. They're gathering the FLDS people are gathering in North Dakota, and they have every right to do that. But to say that, gosh, we just went up there because he had a grandmother or somebody had property there, he sold all of his $500,000 house in Kingston. Well, I don't have any money. Bought a new truck. Well, that's not mine. Bought a new house. It's in someone else's name. I mean, all of this, what I call lies. And frankly, nobody cares as long as you don't take somebody else's child and then say, oh, we provided her with a great life. They should have no contact. Thank you.
I guess the two issues that the court takes issue or wants addressed. I fully understand Mr. Jeffs loving this little girl. He raised her. Of course he loves her. Of course he wants her. But where is any legal relationship whatsoever between Mr. Jeffs and that child? I don't see any. I don't know if Sarah and he are divorced, but she didn't have any either. I mean, there was nothing ever done through the courts to get a guardianship. So there's no legal relationship. And he just married her aunt. That's all he did.
So he and Rose are biologically brother and sister.
Oh, okay.
Yeah.
I missed that. All right. So but still, that's not a legal relationship with the child.
Understood.
And the second thing is, I guess I take issue with him not knowing or saying he didn't know that there was a court order. I mean, he hid out. He had to know everybody was looking for him. Sheriff's texting him, doesn't respond. Well, the reason he doesn't respond because he doesn't want to get caught. He obviously knew that the law was after him and was trying to get the child back. And what does he do? He goes to a different state and hides out. Those are the two issues that I have a problem with. I have no doubt he loves her dearly. I have no doubt she loves him. But you can't just not have a legal relationship and take control of somebody. And you can't hide out when you know that there's the court order and the law's after you. You have to face it. So that's the issue that I have.
And Judge, those are both really fair points. I guess the response on the first issue, that there was no relationship, the biological mother was not in a position to take care of this child when the child was 7 months old. And the biological father had left, I believe it was the community at the time, and wasn't providing support to Ms. Jeffs. And so she felt like there was no other option than to give her over to a caring relative. And there was always an understanding that she would be able to have the child back. And so, as you mentioned, there was no legal relationship. So she still had legal rights to get that child back. And I think that that's why you have a plea in this case, is he recognizes that they never did anything through the courts. And quite frankly, maybe they could have. Maybe they could have petitioned the court for some kind of guardianship or something. But they didn't. And you have the defendant's guilty plea today because of that. And quite frankly, he suffered quite a bit because of that. He spent more than 2 months in jail. And he is entering a guilty plea to a felony, exactly for the reason that you mentioned. I think that the knowledge, it may have been that he was hiding his head in the sand a bit. He just did not receive a copy of the order. And for the court's clarification, that order came from, I believe it was some sort of custody matter in St. George between the biological mother and the biological father. So Mr. Jeffs was not a part of that and wasn't made aware of that until that order was attempted to be served. And it was the wrong address. And I'm just...
But at a minimum, for whatever, at a minimum, you get a text, multiple texts from the sheriff. Why is he ignoring them? He's ignoring them because he knows they're after him.
He didn't know that they were after him at that point. I believe that the sheriff was attempting to say, hey, look, we don't want to do something more. Like, please contact us back. And the reason that he didn't, like I said, I think it was he was putting his head in the sand. He wanted to ignore it. And I think that Rose, the mother, would confirm that they were both trying to work through their grandmother, who they both have a good relationship with. And so he was not thinking it was as serious as it was. He thought, look, we've taken care of this girl for this amount of time. We're talking through this intermediary. We'll just figure it out. Of course, now he understands it was just ignoring the responsibility that he needed to step up to, which was to respond and deal with it in a legal manner. And he didn't do that. And quite frankly, that's why he's admitted to the charge today, because he does understand that he didn't have legal authority and that he should have responded and dealt with it in the legal system, and he didn't do that.
All right, thank you. Mr. Jeffs, the court will hear anything you want to say.
Thank you, but I think Steve's presented it well.
All right. Let's have you stand, Mr. Jeffs. Mr. Jeffs, based upon your conviction of custodial interference, a third-degree felony, you are sentenced to serve 0 to 5 years in the Utah State Prison, and you're fined $5,000 plus surcharge and fees. However, all of the incarceration is suspended except for the 73 days that you served in jail, and you get credit for time served. You're afforded the privilege of probation to be supervised by the Department of Adult Probation and Parole for 36 months. All of the fine is suspended except for $950. You're ordered to make minimum payments on the fine, $50 a month. First payment is due in 30 days. The terms of the probation are that you do not commit any more crimes. You obey all laws, whether you're in North Dakota, whether you're in Utah, whether you're anywhere else. You're ordered to obey the law. You're ordered to complete a cognitive behavioral course as directed by your probation officer. You're ordered to undergo any testing that your probation officer may recommend with regard to mental health or anything else. And if there's a recommended treatment, you have to successfully complete it. You're ordered to have no contact with the victim or her family unless approved by adult probation and parole. That's where this is coming down to. I know prosecution says no contact whatsoever. Your lawyer wants you to have contact. The only way that you can have contact with the victim, her or her family, is if there is a written permission given by your probation officer. I'm going to leave that up to adult probation and parole to make that call. If they think there's a good reason that you can have contact after they have talked it over with child's mother, then maybe they can put it in writing. But unless you get that written permission, it's a violation of your probation if you have any contact. And no contact means no contact. No texting, no telephone calls, no face-to-face, no sending messages with third parties, no Snapchat, nothing like that. Understand that?
Yes.
Your Honor, I hate to interject, but could we add also, or through third persons, reported to me today that he and or his wife are having other people or surrogates, so if it could, the same order, directly or indirectly?
Yes, directly or indirectly through third persons. You don't reach out to her in any way unless you get permission from the probation officer in writing.
Understood.
All right, that's the terms of the recommendation. Is there anything else that either side would like to make as a condition of probation or think that I should change?
Your Honor, so my one concern is him being in North Dakota, they would probably have to do the interstate compact with whatever probation services they have up there. I wonder if the representative from APMP might be able to speak to whether or not we can comply with those recommendations based upon the need to have him supervised in North Dakota.
Do we have anybody representing APMP here? We do. We have Ms. Cowley?
Yes, I'm here, Judge. We'll be able to accommodate that, Judge. He'll need to report into our office today so that we can get everything started for that compact, and then he'll be instructed on how that's going to work. So.
All right, do you know where the office is in Richfield?
Yes.
You're ordered to report there today.
Okay.
That's okay.
All right, anything else we need to cover?
Nothing from the state, Your Honor. Thank you.
Just the one last thing is we'd like to put on the record that there was a stipulation that if he's compliant, that there would potentially be an early review at 18 months. And there was a stipulation for a 402 if he was compliant.
Any objection to those being in the judgment?
Correct statements and no objection.
All right, that's part of the order.
All right.
Judge,
Those will be included. All right, Mr. Jeffs, the court wishes you well. You've been polite in court. There's no question about it. You haven't been a disruption. You've been polite, and the court commends you for that. The court expects you to be compliant with your probation, expects you to succeed. Thank you.
Thank you.
Thank you, Your Honor. If I may be excused.
You may.
Thank you, Stevens. You're awesome.